All right, good evening, everyone. Good evening. Can we all hear me?
Hello, good evening.
Hi,
I
good
can hear
evening,
you.
Ethan.
Okay. Um, my volume seems to. Well, good evening. I trust you guys can hear me. Thank you so much for joining into this session. We are happy to have you in today's class. Right. We'll be starting. We'll be starting shortly. Um, we'll be starting shortly. Yeah, good evening. We'll be starting very soon. We're trying to get our mentors to join in on the call, but I can see Mr. Rakesh's note taker is already on the call, so we expect that he'll be joining us shortly. But not to waste any time, welcome to class, everyone. Good evening. It's nice seeing all of you here. So far, we've made significant progress in the patent drafting class, and all right, please, can we just give me a moment? Thank you. Okay, so we have a moderator, a different moderator in class today. All right, Mr. Nifemi, back to you. Please, you can take over the session.
Okay, good afternoon, everyone. Oh, yes, good afternoon, everyone. Just like Mr. Williams said earlier, I welcome everyone to today's session. My name is Nifemi Abayolayeli. I will be the moderator for today. Yes, we are excited to have you all here for this or for today's experience, which promises apparently to be enriching. Today, we have a wonderful lineup of two mentors who will share their insight and expertise on drafting patents, on patent drafting. Uh, our agenda today includes mentor presentations, mentees presentations, feedback sessions, and the question and answer segment, where you can interact directly with our esteemed mentors. So I implore us to make this session interactive and engaging. You're also encouraged to put your videos on, which I will also be following the same now. And so without further delay, we begin. I don't know if you can see me now.
Yes, we can
So
see
yes,
and hear you.
first let's talk about the first thing we're doing is sorry.
We can see and hear you.
All right. So while we are waiting for the mentors, let me just give us a brief profile of the mentors. One of our mentors today is Mr. Rakesh Sharma. He has had a thorough but multifaceted career spanning nearly a decade in patent analytics, drafting and prosecution for the US and EP jurisdictions. He worked closely with various engineering teams and supported their portfolios from idea incubation to innovation management. Mr. Rakesh has excellent understanding of patent law, claim interpretation, and drafting skills. As a seasoned professional, is readily engaged with various end-to-end IP services at different levels and provides intelligent IP solutions. He emphasizes more on promoting innovation for a better world. He loves drafting patent claims, keeping all the infringement perspective in mind. Furthermore, he has a he has a strong he has a strong bent of mind towards IP automation and has sound knowledge of various IP tools and techniques that can be used for either improving quality of IP or Mr. Williams. All right. So Mr.
Yeah.
Rakesh is a Mr. Rakesh will be coming in now to give us to also make us learn from his wealth of experience. Let's sit down tight and enjoy his session. Mr. Rakesh, please are you online, sir?
So thank you for very wonderful introduction. So are you able to uh, hear me?
Yes, we can hear you,
Yes,
sir.
we
We can hear
can.
you, sir.
Okay. So I'm sharing my screen. Just let me know once it is up, and we will start discussing about today's topic.
Yes, you can see your screen.
I'm unable to share my screen. So can I share with you and you can present?
Okay. Mr. Williams.
Wait. So I have shared the presentation slides in the chat window. Can you please uh, open and share that? I am unable to share and turn on
All
my
right.
video also. Everyone also in the meeting can download the presentation slides from here. This includes today's session as well as the last session we conducted last Friday. So, are you able to download it?
Yes, sir. Just give me a moment. We'll be
Okay.
putting it up soon.
If you give me a chance that I will leave this and then rejoin again. Meanwhile, you can download this and share the screen. Just give me a moment.
Sorry, I'm having a little challenge putting up the screen, but give me a moment. I'll be doing that shortly.
Hello everyone. Now I am able to share my screen also. Please let me know once you are able to see my screen. So, are you able to see my screen?
You can scream.
Yes, I can see your
Yes, yes,
screen.
sir. You can see it now.
So, I will quickly give you a brief what we discussed in last session. It was about the patent drafting and why it was important. We have covered these two sections, introduction to patent drafting and preparing the patent application. Today we will be discussing only about the patent claim design and drafting. Claims, what are the types of claims and why these are important. So feel free to ask questions if you have any. And everything is there. If you want to just check, you can check these slides. And for claims also, let me give you very good examples. So for suppose this example we discussed last time, if somebody has to write the claims, so how it should be written, like this is an apparatus because claim is having a specific structure. So that includes all these things. Wait. So now today's session will start from here, patent claims. So anyone having any idea what are the claims and why these are important? Anyone? Yes, no,
Yes,
any?
yes. So, with respect to claim, claim can be seen as an attribute that a particular invention has that an inventor wants to claim. Let's say, for example, a particular invention deals with a touchlight, a design of a touchlight. So, an inventor would like to claim a specific design. An inventor would like to claim how he or she is able to design that particular uh,
Right,
torchlight that will be distinct from other torchlights. And one of the importance of claim is that it protects an inventor's right on a particular invention, so that any other person will not copy that particular design or that particular claim. Because if a particular inventor exhibits a particular invention and does not claim a specific attribute or feature in a particular invention, the inventor does not have claim or does not have right over that particular attribute, because that particular attribute was not claimed by the inventor.
right, wonderful. Very good explanation you have given. Thanks for this detailed answer. So, can anyone tell why claims are important in a patent? Like, what kind of role claims play, or what is the importance of claims or use of the claims?
Okay, the use of claim is it helps to show the extent or scope of protection that can be given
Yeah,
to the invention. So that's the essence, to be able to show the extent of protection that can be given.
right. Very well said. So, extent of protection, if they provide, what will happen with that protection? Like, how you will use it for the business purpose? if claims are providing you the protection, how it is beneficial for you or your business?
Okay, how it is beneficial is for that period of time that is being patented, it's exclusive to you so that nobody else gets to work on your idea or your invention. So it gives you an exclusive right for that period of time. So nobody goes ahead
Right,
to develop on it.
right, exactly. But and if somebody is trying to use your idea, then what will happen?
If someone else goes to use it, that's an infringement on your right once if it's been patented.
Yeah, and if they are infringing, then what will happen?
You file for a lawsuit to claim
Right.
damages.
Right, exactly. So this is the overall story behind the claims, and you all knew it very well. So I appreciate your knowledge, your understanding, and the way you are responding. So claims indirectly help us in protecting our idea to exclude others. And if somebody is using it without our permission, they will have to pay the damages in terms of royalty or licensing fee. So indirectly, this is supporting the business by excluding others or by generating money in terms of licensing or royalty if you are willfully uh, giving the rights to someone to use or make your idea. So patent claims are having some specific structure how these should be read, and the format is also specific in their parts. So one last question that the what should be the scope of the patent claims? Whether these narrow claims are better or the broader one would be better? What kind of claims you would choose for your invention or for your client's invention? Broader ones or the narrow ones?
Sir, for a particular claim or for a particular invention, I would advise my client to choose a broader one in the sense that it will encompass all form of attribute of that particular invention without leaving any attribute unclaimed. Because if a particular attribute is left unclaimed, so my client will not have exclusive rights for that particular attribute of that invention, and any other person can take that particular attribute and create his own from it, and my client cannot seek any form of redress in court based on that particular attribute that is omitted. So I would advise my client to choose a broader one so that it will encompass all the attribute or all the features of a particular invention.
Great. Anyone who is in favor of having narrow claims, or is there any benefits of narrow claims?
I would like to. I think your claim in general should be as concise as possible. I think it
Right.
should. I think it should be concise. I think what's it called? Because the whole purpose of a claim is to establish. It's just boundaries, really, and I think what's it called? I think much as we want it to be broad, I think it should generally be concise. It should be
So
concise. That's
can you explain what do you mean by concise?
okay. What I mean by concise is the focus on the products. Now, for instance, now I think okay, okay. I think it should be a bit comprehensive in relation to the focus, but it should not be so broad that it begins to cover things that are not entirely, yes, they may be related, but they are not directly related. Because I think in a bid to protect our inventions, sometimes we broaden the scope to sort of make sure that even some little bits are, what's it called? that are ordinarily a bit, an exaggeration, at least, in relation to this, we sometimes try to inculcate it. I think it should be, comprehensive and detailed in terms of the products, yes, but not so broad that you sort of go overboard. I just think, I don't know, I think I'm having trouble explaining this, but I just think it should be concise. It should be a bit brief. I think in the option you give, I think narrow is a bit more suitable generally.
Right. Actually, it all depends from case to case basis. Uh, for something you have invented and there are plenty of similar inventions, then it would be advisable to go with a narrow scope. Then it chances of getting it allowed will be high. But yeah, I agree with you on the concise. Concise means having all the essential limitations and having all additional limitations in the dependent claims. So agree with you, but you have highlighted one good point, that keeping the product features in your mind, right? So whose products feature, your own products feature or the product of the competitors? If you are writing a claim, so whose feature you will keep in mind, your product or the competitor's product?
Okay. I think if you're applying for a patent, you need to consider the competitor's product to make sure that you're not overlapping into theirs. But I think generally your application should cover your product in its entirety and explain why your product is unique in relation to the competitor's product to make sure, you know, to improve your chances of being granted.
Okay, so if the claims of your invention is having all the features of the competitor's product, what will happen?
Uh, I think what will happen is if it has all the features of the competitors' products, you might be in breach of their own rights if they have a patent. But generally, it may not be. Your application may be denied on those grounds.
Yeah, if invention is filed at a later stage and product is available in the market at a earlier stage, but if invention is filed earlier, then that product will be infringing on your patent. So it all depends on the timelines, what kind of actions are happening at which stage. So timeline is always very important. Whoever is having the earlier timeline will be having the advantage. Got it? So we
Yes.
will talk, yeah, we will talk about these. So in other terms, claims or like the patent claims in itself allow you to set a boundary, like suppose you or anyone is constructing their house, so they create a boundary with a fencing, right? And some people write at the outside that trespassing is not allowed without permission. So patent claims help you in creating the boundary for that particular technology for which you have invented something new. So if somebody, like any infringer or competitor, is entering into that boundary, then they might be infringing. And for that, you can disallow them to enter into that boundary or that sphere. Or if they still want to be there, they must have to pay the rent in terms of royalty and licensing. This is as simple as I can explain about the patent claims. Any questions anyone has so far?
Yes, sir.
Please.
Okay, sir, I want to ask with the narrow and broad claim, I didn't get which the conclusion, so which is better or it depends. That's the clarity I want to get between the broad
See,
and narrow.
every time, every question will have same answer, and it always start with it depends. Because every case, every invention, every inventor, every company has different scenarios, different parameters, different competitors, and different market size. So we cannot generalize, we cannot give one stop formula that one size fits all. So every time you must have to decide based on all these possible parameters. Got it?
Yes, sir. Thank you.
Suppose, for example, uh, I had invented a new mobile phone, or in mobile phone, you mean to say this touch screen I had invented. So, what would you suggest? Whether I should go for a narrow claims or broad claims for this touch screen only? Are you able to see my phone? So, for mobile phone,
You can see the phone.
narrow or broad?
Sir, for I believe for mobile phone it should be narrow because
Why?
if we are dealing with mobile phone, you know, basically what you are dealing with is the shape and the structure, how the mobile phone is. So if you are going to patent a particular design in mobile phone, basically just is your own the what you'll be focusing on is the shape, only the shape or maybe the color or the type of color of that particular, but majorly it should be in relation to only the shape per se. The shape only would be precise so that it won't infringe on any other phone that is being marketed or produced.
Right. This is the very good definition here in WIPO drafting manual you can get. Are you able to see this WIPO drafting manual on my screen?
Yes, sir.
Yes, sir.
Yes, sir.
Okay. Let me see here. It's a separate chapter, broad and narrow claims. You can see. I will share this or you can download patent claim design, broad and narrow claims. So you can read it from here when it is needed to go for broad and when you should go for the narrow claims. Got it? But there
Yes, sir.
is
Noted,
very
sir.
good, but to have a balance between the two, one they has given a very good definition, because if you go for a overly broad claims, then it chances of getting the allowance will be less. Why? Because of the number of prior arts that will disclose all those features. Got it? So there should be a balance between the two, and it has given a very good definition here. Uh, Let me just check quickly. Mm, That is a very good definition about it. Like the claim should be broader enough to cover the infringer's product, but it should be narrow enough to overcome the prior art. So there should be balance between these two. If you want to ask me to give you a formula, so this is the formula which is written here. I will fetch that line and will share it with you. Coming to the main point. So broad and narrow will depend on the like the size of the prior art, like the how crowded that particular technology domain is, and the number of infringers available. So there should be a balance between the two, because overly broad claim, the chances of getting allowance will be less. But if you are having overly narrow claims, then any competitor will easily bypass your technology by making some obvious variation or changes into that narrow. So there should be a balance between these two. You must have to take care of both aspects. So now the question arises the types of claims like apparatus claim is there, method claims is there, we call like the process claims. So for example, you might have seen uh, the chocolate or ice cream are being manufactured in the factories by using the automation, or the automobiles like the bike or cars are being manufactured in the industries, right? So for that part, if you have invented a new car, so what kind of claims you need to have on that car? What type of claims you will write? Or if I have to change the example, consider the same example of this mobile phone itself. If you have invented a new mobile phone, so what kind of claims you should write to protect your mobile phone?
That would be apparatus claim, sir.
Only apparatus? Okay. Anyone? Why you will write apparatus?
Well, because by the definition of what apparatus entails, it basically has to do with you know the processors and how the car or how the phone works. Basically, phones works differently. So the apparatus claim would be definitely be more
Right,
appropriate. But, exactly. So that apparatus claim is more appropriate for phone.
right. And when you will go for the method claim, if you have invented some way of making things, any like making mobile phone or the car or laptop or any other project like product, if your method is unique, then you can go for method also. And method we can use in two different ways: method of manufacturing something or method of using something. So these two types of claims we can also claim. Suppose for the same mobile phone, you can go for apparatus claim. Also, you can go for the method claim. Also, the method you have followed in manufacturing this mobile phone or this screen only or this camera. If that is unique, you can go securing that method also. So, and method claim will list all the steps, and this method will go in the continuous statement. Suppose this is a method claim for making tea. So this is the preamble, a method for making tea. Comprising is a transition phase, and these are the all steps with ing form. We call it gerund. So these are all the limitations for making tea, like boiling water, adding sugar, adding tea leaves, adding milk, and filtering the mixture. So why method is required? By using this method, if you are training a robot and then robot is following all these steps to prepare the tea, like in a coffee vending machine, then method claim is important, right? So it all depends on the scenario, what kind of scenarios you are going to cover in your claims. So there are other types of claims like the system claims, computer implemented method we generally called CRM claims. Like a software code is there which you have stored in the memory in terms of flash drive, like for any of the mobile applications, it is a code which is stored in the memory, and whenever instructions that are being executed by computer, it performs some kind of action. So we call it computer implemented. For all type of software related inventions, these types of claims are always important, because every time a software is stored in a medium, computer readable medium is nothing but that memory of a computer, be it RAM or ROM, permanent memory. So computer readable storage medium is the memory, and not only limited to computer but for mobile phones and every type of electronic gadget which is having the memory and a processor which execute those instructions, that software code itself. Suppose in your mobile phone it is having the memory, and instructions are nothing but the software applications you have downloaded in your mobile phone. For example, Facebook is there, Google is there, or any mobile banking related application. So these are nothing but the instructions which are stored, and when you will open that application and sign in or perform some kind of actions, it will give you some output. So this is computer implemented method. Marcus and Japson and means plus function, these are different claims we use depending on the requirement or nature of the uh, invention. Marcus, actually, these are the names came after some kind of evolution in the IP industry. So Marcus specially deals with to like write the either independent or dependent claim and to cover a single group of elements in one single line. So it is having this specific format and always being used this format itself. Suppose if we are writing a metallic element, then metallic element is selected from the group of copper, lead, and gold. So metallic element could be any of these three. So it is Marcus type. Jepson claims are generally being used in Europe and China. We call it two-part claims also, and these are identified by this word. It is written there, characterized by, and these are generally narrow. Why? Because uh, by writing this claim divides the entire this phrase actually divides the entire claim into two different parts. The first part prior to this statement deals generally about the state of the art, and after this statement deals about the novel features of the invention. So it quickly divides the claim into two parts, and that's why we call it two part claim. For any of the European or Chinese case, you can see this very often. This is means plus function. In means plus function, as the name suggests, rather than writing or talking about the particular structure, we are simply saying by means or by using the means, we are performing this function. Suppose I will say that I am writing something by means of a writing apparatus. So rather than saying simply I am writing using a pen, I am saying by means. Same example you can see here, an apparatus for cooking rice comprising a means for holding rice. Now, if you want to cook rice, what you need?
You need a pot, water, bit of
Yeah.
salt,
So
and colander.
other than writing a pot, what we are writing a means for holding rice. Got it? So uh, it will cover a pot, a vessel, a pressure cooker, any kind of thing, so to keep the scope broader. And why we are writing a means, it could be anything, whether the metallic, non-metallic, wooden, or sorry that clay, anything it could be. Got it? So we are not specifying here, so this kind of claims are having some their own interpretation. So these are means plus function types claim. Got it? So these are some kind of examples I can give. You can check all such examples in that Wi- WIPO drafting manual. So I am giving you very quick examples. It's like it is written and writing apparatus comprising. So the first part, which is highlighted in blue, this is we call it a preamble. This is transition phase, and this is the body. You can read it and tell me what this claim is about, or by reading it, what kind of picture or like comes in your mind. Just read it quickly and tell me which product we are talking about here. Have you read that? Anyone?
For example one, I think what we have is a different kind of pencil, a unique reversible pencil that comes with an eraser. And for example two, I think it's a workstation table. Because I mean, akin to that where we have the engineering table where they used to attach all those I think the T's and all those things. I don't know. I can't recall. Yeah.
Right. So is it clear? It is talking about pencil with eraser and light, right? And it is talking about a table. So simply rather than writing table, we are writing an apparatus for holding items, which is having four legs, 16 screws and a top. So can you tell me that whether if somebody should write in this way, example 2, so whether it is a narrow claim or broad claim? Example 2.
I
Is it
think it's a broad claim. I don't think it's narrow because it doesn't narrow down the purpose. It just says
if
for holding.
if apart from four legs, if somebody use two legs or three legs or five legs, but having the same table, then, and rather than using 16 screws only, somebody use 8 or 20, then can they say it is infringing?
Generally, I wouldn't think so. I wouldn't think so unless someone else has invented it because then it specifies the what's it called? It specifies a unique design, possibly. I mean, they
Right,
haven't. Yeah.
totally agree. So for format of claiming, it is clear. It is having the preamble, then transitional phrase, and then the elements of the claim. Every time you will see a patent claim, it will have this structural requirement every time. And a patent claim in itself is only one single sentence. Like if you will see here, it it has started from here, a writing apparatus, and having the colon, then semicolon, semicolon, and then one period here. So this is in itself is a one single sentence. A claim, no matter how narrow or broad it is, it will always be one single sentence. Always keep it in mind. The independent claim or then the dependent claims, one claim will be only one single sentence in all the jurisdictions. It is not different in anyone. Got it?
Noted.
These are these are the different examples of transitional phrases. Like I had written here with comprising the same thing and written the same claim by using consisting of. Can anyone tell what will be the difference, or is there no difference at all by writing these two words? Rest of the part yellow highlighted is exactly same in both. So how this green highlighted portion will create a difference?
For the first one, an apparatus is comprising. The comprising gives room for is open-ended. It gives room for other things to be added. Then for the
Right,
second one, consisting of is closed. It means this is the only thing. Is a full stop. Nothing else can be added.
right, absolutely right. So where you should write consisting of and where comprising is better. Can you give any example? Okay, I will tell. In pharmaceutical, where you have invented some new medicine or new drug, then if drug is having three or four chemical compositions and no other chemical composition could be added, then which one you will use transition phrase, comprising or consisting of?
So you said where there is no nothing else, where there is no other thing to be added. Did I get you right?
Right. Then,
Okay, where there is no other thing to be added, that's where you use consisting of.
right. So maximum times in pharmaceuticals or other such inventions, like it depends every time on to case basis, you will write for such cases consisting of. But for mobile phone, because there are n number of features, you cannot cover all the features in independent claim, so you write comprising. So where you are not sure whether the other things, other elements can be added, so you will go with the broad ended. So maximum times we try to go with the comprising, but for special cases where consisting of is advisable from the business perspective, we write it only. Got it? So this is another additional detail and example of the transitional phrase I had already given. So there are two types of claims, independent and dependent. Independent claim in itself is standalone claim. Dependent claims are those which are dependent on that independent one and having additional limitations. So all the additional limitations, in addition to what we had discussed in claim 1, we call these limitations as well as the features. So don't get confused with feature or limitation. These two we use interchangeably. So these we can call features also because it is a apparatus like the pencil or writing apparatus, and these are the features of that pencil. Got it? So features are also, but in claim terms, we call it limitations because the more the limitations will be, we call it narrow. If limitations are less, we call it broad. So limitations and features, we use it vice versa. So this is independent and it is dependent. Got it?
Yes, sir.
So this is all from my side for claims perspective. We will discuss about other drafting examples and rest of the things in coming sessions. So if you have any questions, feel free to ask. I would be
Um,
happy to answer.
Good evening. I have a question.
So
My
please,
name is
please,
okay. Uh,
bol.
okay. Yeah, I said my name's Damilola. My first question is regarding you said it follows a general format, the preamble, and I didn't catch the other two things, but I'll read up on the slides. Uh,
Right.
yes. The this thing, is it possible that you could have a different format, or is that a prescribed form that everyone must follow?
See, maximum countries have followed the same format. And for one invention, if you are filing in your country and planning to go and file in other countries, so it is always better to follow a standard format, because if you will follow some local format or that format which only your country permits, but that is not allowed in other countries, then you would have to do the same exercise again. And if you are hiring a patent expert, then you would have to pay him again for generating two different formats. So it is always advisable. And WIPO drafting manual I had shared, showcased you, it is also having the same. So I would say around more than 142 countries which has signed the WIPO membership, they all follow the same format that I had showcased you, that preamble, transition phase, and then body. So all the countries follow same format.
Okay. Thank you. Thank you. That's all from.
Did I answer your question?
Yes, you did. Thank you. Yes, thank you.
Well, any other? Anyone?
Okay,
Any
sir,
Yes, sir.
questions? Yeah.
I have a question, sir. Okay, sir. In your last explanation, you mentioned something about limitations and features, and that they are used
Yes.
interchangeably. And I don't know, I didn't really catch that phrase. The explanation between the two of them, limitations and features.
Can you please repeat your question?
Okay, you mentioned something about limitations and features, and that they are used interchangeably. I don't know if there's any difference between the two of them, but you mentioned something about them being
No,
used.
actually, it is just the way we speak or use this terminology. Otherwise, there are no difference. These are same actually. It is claim, and in that claim, some countries, I will say that in US they call it the features, and in Europe they call it limitations. So this might be the difference. Otherwise, exact meaning of it will remain same.
Okay, sir. Thank you.
Yeah, you can call it either the limitations or the features. It won't make any difference at all.
I got it, sir.
Yeah,
Okay,
somebody was.
Nancy.
Yeah, please.
Any other question, please?
Yes, yes, sir. I actually have a question. My question is that, okay, let's take, for example, there's a particular invention that has been patented. So let's say, for example, a particular phone that was invented and that was patented on it. Okay, let's say the phone has design A, B, C, and D in it. So another product or another person or another inventor wants to patent another phone, and it's having the same design A, B, and C, but the only difference is that he's now adding the design E to it, but the design A, B, and C are the same exact design of the previous or the prior inventor, but he's now adding design, another design to that particular design. Now, would you now say that it's infringing on design A, B, and C of the invention that has been produced before, or would we say it's not because he's adding his own part of design to it, apart from the design that has been exhibited on the first invention?
So you have asked a very interesting question. So thanks for asking this. Actually, many times this happens, but no, there is no such scenario where two people having like living at separate or different locations are able to create exactly same design or same invention. Their solution to some problem, solution might be different, but problem might be same. But no two people can create exactly same formula. Only in one scenario where one person is copying or stealing the idea from another. Otherwise, if two people are working on one project, but they do not know each other and they are living at different locations, then whatever solution they might be creating, there might be some difference into that. And if the solutions are solving one problem, but both of them, those two people are having unique solution, then both are eligible to get a patent, if unless or until they are not copying from each other.
Okay, sure, sir. I now understand it, sir.
Yeah.
Because the reason why I'm asking that, because there are some similar products that I would see, and it will have the same design or same shape and all. So that's why I'm asking.
Yeah, you have used two words. One is same and the second is similar. Same means exactly same, but similar means having similar features but exactly not same. Because you can consider the example of the human beings. We all human beings are similar because all are having two eyes, one nose, two ear, two hands, two legs, right? So we all as a human being are similar, but we all are not same. We all are different. So can you say that we all are same?
No, sir. Just we're just similar, but not just the same person.
The same answer applies to inventions as well. That similar and same are two different words. And if you will say something is similar, doesn't mean that the solution it is providing is also the same. Yes, next. Did I answer your question?
Yes, of course, sir, definitely, sir.
Okay. Yes, who's next?
All right, Mr. Rakesh, thank you very much for your presentation. Really appreciate it. It's been an amazing session. At least I know that I owe something on to me that a patent claim should be broad enough to cover inventors' products and narrow enough to protect the inventor's product. I'm really holding on to that. Thank you very much. It's been a pleasant session with you, sir. We have our second mentor on for how to come up in the person of the distinguished uh, Madam Amusa Shukrat Budupiola. She's a seasoned intellectual property consultant, analyst, and educator with public sector experience. She holds a master's degree in intellectual property from the prestigious African University, Zimbabwe, in collaboration with WIPO and the Japan government. Shukurat is an alumni of the World Intellectual Property Organization, a member of the WIPO International Network for IP Education, as well as a training facilitator at the Next Innovation Hub. She was a member of the planning committee of the WIPO National IP Essay Competition 2023 and resource person at the National Intellectual Property Conference (NIPC). Shukurat is an accredited agent of the Intellectual Property Offices in Nigeria and the pioneer of the Intangible Knowledge, an educational platform which is responsible for fostering, among other things, intellectual property advocacy, awareness, and education. Let's all sit tight and learn further from her on claim design and drafting. Madam Shukurat, we are glad to have you on, and we are here to listen to you. So, mentees, please let's just sit tight again and listen to her too. Thank you very much. Madam Shukurat, please, are you online, ma?
Hi, good afternoon. Can you hear me? Evening already.
We can hear you. We can hear you.
Yeah, so sorry I joined late. I didn't get Mr. Rakesh's presentation, but I'm very sure he has done excellently well. I'm not in a good place to actually talk for long and share my screen. I just joined to just support Rakesh. So when you are talking about claim drafting, just like Rakesh have said, the claim is like the art of the invention. And if majority of you were around last week for the session, we actually went through patent search using some databases. I think we checked the patent scope and also the USPTO. Yeah, I guess. So when it comes to claim, it's majorly the act of the invention. And so when there is a form of infringement, the first thing you want to check is the claim to see if really they are the same, just like Rakesh has said. Even though they might be similar, there might be one particular essential element that might be different from the other invention. And as such, it is important that the body of your work have to reflect in your claim. So whatever it is that is in your background should also be in your claim. So you should not have a claim whereby what you are putting in your claim is not in the background of the invention. No, everything has to like fall in place. And with claim, we have the preamble, the transition, and the body of the work. Just I'm sure Akash have said that already. Then you start with your preamble, then followed by your transition, then you have the body of the work. Then when it comes to preamble, when you are starting, you want to use A. Then in your probably your second claim, you want to use D because you are referring to the one above. So the article kind of, you have to understand how to use the article of A and D. And then with transition, you want to use a transition that is broad enough. For example, you want to use a transition like comprising rather than consisting of, because consisting of is kind of limiting. When you say consisting, then it has to be those exact thing. But when you say comprising, comprising is broad enough such that even though you don't mention that exact thing, it can still come in one way or the other. Then you also have your independent claim. Your independence claim is the first claim. And like Rachel said too, it has to be like broad enough. Then in the following dependent claim, you can now start narrowing it in the dependent claim. Like we said last week, then it's possible for you to have about one or two independent claim in the same invention. Say, for example, the invention has to do with a product and a process. So if it's a product by process kind of invention, then it's possible you're going to have two independent claim, one for the product, one for the process. Then you have some dependent claim that will now follow those independent claim. So yeah, I think I'm just going to stop there. I really don't have much to say. I'm sure Rakesh has said everything. So if you have questions, yes, I can take questions. Yeah, thank you.
Very much, man. Thank you very much, Mike. That's what they call short and mighty. I really appreciate that. So, the mentees will be going on to the mentees presentation now. Please, I hope they are prepared, they are ready for the presentation. Mentees, who will be presenting for the mentee?
Okay. Good afternoon, everyone. Can you hear me?
We can hear you clearly. We can hear you clearly. Good
Good
afternoon.
afternoon. I'll be making the presentation, but I don't know if you can share the slide from over there, like from your end, because I don't know how to, and I was hoping that Mr. Dennis would. Okay.
All right, please give me a moment. I will do that from my end, but you can go ahead and start the introduction.
Okay. Okay. Can everyone hear me? Like, please just indicate if you can.
Yes, I can hear you.
All right. Thank you. Okay. The topic given to us for week 4 was patent drafting, patent claim and design and drafting. So that's what I'll be talking about this evening, patent claim. Okay, before I go, before now I normally call it patent. So sorry if I will call it patent during the course of the presentation. It was when I started this course that I got used to the word patent. I normally call it patent. So don't get mixed up. If you hear patent mistakenly for me, just it's the same thing. Patent. For me, sorry. Okay, let me go. Let me go on with the first slide. I don't know here. I don't know. Okay, thank you very much, Mr. Dennis. You can see the slide. claim construction. So in patent, we have to know like what is the claim and construction of a claim. That's the first thing you know when you're drafting your claim. So if you're constructing your claim, a claim is just the legal boundaries for an invention. In a short form, just that it's the right you're trying to protect, those boundaries that you don't want anyone to come in, that exclusivity that you're trying to protect, that's your own mind and invention. Those are the legal boundaries you're trying to protect. So in drafting a claim, in claim construction, that's the major thing in protecting, that's the major thing to look at. And in structures of a claim, we have the first part. We have three parts, which have been mentioned before, but I'll reiterate: the preamble, the transitional phrase, and the body of the claim. The preamble is the introduction of the claim, is what it's for. Like, this thing I'm bringing is for, like, it's just like what this invention is for, the introduction. And like it was said earlier on, your preamble should not be narrow, it should be broad enough to like cover what you're claiming for. So if like the example you are saying in by your right hand side, when you're claiming for, instead of saying a shovel, you say a shovel for digging. Instead of saying a bucket, you can just say a carrying device or something. Or like the one we got earlier, instead of saying a pen, you can say a writing device. You're just telling them what it's for. So it's for digging, and this is for carrying, and this is for writing. So the preamble is just what it's for. Then the second phrase is the transitional phrase, and is more of like explaining what is composed of the transitional phrase. And it can either be comprising and it can be consisting. When we say it's comprising, it means that these are the only things that are inside. Like, it's comprising, it's open-ended. Comprising means it's open-ended, meaning these are not the only things that it's made up of. But when you say it's consisting, it means that it's close-ended, nothing can be added to it. So in your transitional phrase, we have the comprising. You have to know what is comprising and what is consisting, and how to phrase the work when you're transiting. Like if you want to make something that an invention, maybe you want to put something that have never been used to it, then you can use consisting of, like, most especially when that is the only thing that is being used to make it, or that's the fundamental thing that is used to make it. Like the example they gave before in pharmaceutical, like consisting of this chemical, or in engineering, if you know that this is the only thing that is used for consisting of metals, consisting of titanium, this is it. But when we come to other things like making of a car, you cannot use consisting of, because we have other things. We can even have leathers and all, so it has to be like comprising. So every invention has its own words to use. So you have to know the words to use that would help you protect the scope of what you have invented. So we'll go to the body of the claim. The body of the claim is the list of the inventor key elements and their relationship. You're not just listing the elements, but you're also bringing its relationship, like you're joining it together, like this is what this do and all. And in it, we have the dependent and the independent. The dependent, they stand on their own. They're just like their brother, just listing it like this is this and that and that. But when you're claiming a dependent claim, it can't stand on its own. It's more narrow. You're bringing a claim that earlier on stated, and it's dependent on that claim, and you're saying its function. Like we said, the body of the claim is listing the inventor's key elements and their relationship. So you're bringing that claim and you're also stating that this is the relationship between this and that. But in a independent claim, you're just listing it true. So please, let's go to the next slide. Okay, thank you. So in drafting the claim after all that, after and before all that, before you go into patent filing, and we have to do prior art. And before now, I believe that we all know prior, so I will just talk a little on it. Like, you know that any invention that is already in state of the art, like something that is already commonly known, it will not be granted. Like in that art or in that field, field is a better word. It means that everybody already knows that this and this and this is used to make this. You cannot make an invention that will be like it's exclusive to you. It can't be exclusive because there's already prior knowledge of that. So in prior art, is like the first thing you do before you make your claims, you go on to search, like, were there publications before now on this? Like, if you want to find those patents in those communities whereby all African countries have their patent protected, you have to check, like, did anybody fight for this in other countries? I'm coming to protect this and all that. So the prior art is like knowing if this idea I'm having has already been used or is being used by somebody else, because the idea might come to you as new and all that, but it might be in process. Like something that happened some days back, and I was talking with my son and he was just like, Mommy, I think I want to bottle up water and sell. And I was like, don't you think someone have thought of that before? Like, so just like this, some people might just be like, I think I want to do this. Like, how do you think we get water? Like, people are thinking of this. You can think it's a good idea and all that. So you have to like check, like in that field, have they been publications? Are there sales going on in that period again? So you would not just waste your time or to make a publication or make a claim where you would not get those rights or relief. So please, let's move to the next slide. Best practice in drafting claim. Okay, thank you. In drafting a claim, the best practice in drafting claim has been listed here. One, you have to understand the invention thoroughly, like conduct a detailed analysis of the invention, the novelty, the utility, and the inventive step. You have to have like a very good knowledge of what you want to protect, because if you don't have a good knowledge of what you want to protect or what the person seeks to protect, you might end up narrowing your scope to something that would end up infringing the rights of the invention you're protecting. So you have to have a good knowledge of what you want to protect. Then the second one is determine the type of claim. You have to know if it's an independent claim or a dependent claim. Then clarity and conciseness. Avoid unnecessary legal jargons and keep the claim. Okay. So in patent drafting, your word has to be clear, like, because the person you're drafting to or the person you're filing to is not there. You're not going to be there to explain to them, like, this is what I want to do. So if you should use more clear terms, if it's in engineering or something like that, you don't know if it's someone that is not too learned in that field. So you have to use a very clear term that anybody that sees the application or the claim will be able to tell that this is what this person was actually talking about. So the next one is proper claim structure. Introducing the invention, the inventor detailed description of the invention, drawing of the invention and abstracts. Okay. You have to have a proper claim structure. Everything you want to claim should be properly structured and described, even down to maybe the screw. If you know that it's only 3 bolting screw that can fix that device, you should properly, detailedly describe everything you want to claim, no matter how small or insignificant you think it is. So that's why you have to have understanding of the invention you want to protect. Then the scope of protection. Ensure the claim are broad enough to prevent easy circumvention. So your claim has to be broad, but not too broad. It should be broad enough to prevent infringers from stealing your ideas. So the scope of your claim has to be broad, but not too broad, but just broad enough to protect that invention you're seeking to protect. Then in cases of using multiple claims, this is when you're not just protecting the invention, but you're also protecting the design. It's best when filing for this claim, you use multiple claims, as seen in this case above in Ariwa Textiles, where the court held that there's a basic distinction between the product claim and the process claim. Now, in registering or protecting just the finished product alone will not suffice. There's need to protect both the process and the product. So when you know that the idea or the invention, the protection lies in both the process and the product, it's best to protect both of them. So when any of it is infringed, you can file for infringement and you can sue for infringement. Then consistency with the specification. When claiming, the words you use, you have to be consistent through it, or like you don't have to use the different words, like bringing misunderstanding. You have to be consistent with the specification. Then you should avoid superfluous word. Do not include unnecessary word or redundant limitations. Things that like this would make them say like this person is not serious, or this person doesn't know what he's talking about, or like things that would avoid things that will make you look unserious, that would delay your claims, like, and then drafting claims, draft claim with infringement in mind. So when drafting your claim, have it in mind that, okay, what about if someone wants to infringe on this and that? So think of things that might be possibly infringed on. Then when drafting your claims, put those ones there that, oh, nobody knew of this, and if I should draft this now, people will start to draft claims with infringements in mind. So in conclusion, preparing claim design and drafting require the clear understanding of the invention, precise language, and strategy. Structuring to ensure strong legal protection. It involves identifying the core invention concepts, defining the scope of the protection, and balancing broad yet defensible claims. Careful attention to prior art, statutory requirements, and the potential litigation risk is essential. Ultimately, a well-drafted claim sets maximum enforceability while minimizing vulnerability. So we had 2 questions after which we compiled this. Question 1 was, what strategy can be employed to anticipate and mitigate potential challenges, such as prior art or competitors' claim? Then 2, how can the use of broad versus narrow claim? Okay, I think this have already been answered though, but impact the strength and flexibility of patent protection. Thank you.
Thank you very much. That was a beautiful one. I think now we'll be having feedback from our mentor. I think Mr. Rakesh is no more. Your feedback on the presentation by the mentee. Mrs. Shukuro. Sure.
Hello, can you hear
Okay.
me?
We can hear you now. We can hear you now.
Okay, I couldn't hear you for some minutes. And yes, I couldn't also follow the presentation for some minutes, but I got the first slides. Well done on the presentation. It was indeed a good job. So I loved how you focused on the topic for the day, rather than just bringing other things that are not necessary. So yes, you did well. I think the only aspect I'll comment on is the trying to remember now. I didn't get the presentation sent to me. Okay, yes, the aspect when you're talking about the preamble. So when you talk about the preamble, whenever you're drafting a claim, you really don't want to put the advantage, because the advantage is not an essential element. So let's say if you say this particular invention, the advantage is that it makes maybe it makes, what kind of advantage can I say? It has a better advantage compared to the others. So advantage is not really an important an essential element. So if you say, like you mentioned, I think you mentioned something like a pen for writing. Now, the use also is not really important for you to put it in the body of the claim. So sometimes the reason why people put it is just so everything can align together, but it's not a compulsory thing that you have to say, okay, maybe a shovel for digging comprising, it's not necessary, or a kettle for boiling. It's not, you can just say that a boiling material instead of saying a kettle for boiling. The advantage or the use should not always be pronounced when you are drafting the claim. Yeah. What else did I pick? I think that was the only part I got in the first presentation. Then yes, I heard you speak about prior acts, and that's very important because at the time the examiner start examining your patent application, is going to go through the test of substantive examination, which has to do with the novelty, the inventiveness, and the industrial applicability. So it's possible that an invention might be new, but it doesn't have inventive step. It's possible that an invention might have inventive step, but it's not novel. So all these criteria have to go hand in hand. Even if your invention is new and it doesn't have inventive step, you're not going to get a patent for it, and vice versa. So you have to make sure that the invention is new such that it can be invalidated by a prior act. So let's say, for example, your prior act has an essential element A, B, and C, and your new invention has essential elements A, B, C, and D. Now, because of everything you have in A, in the prior act, A, B, C, is in the new invention, but it doesn't have D, your prior act will not invalidate the new invention because there's something new which has been added to that new invention. But if your prior act has A, B, C, and your new invention has A and B, your prior act is going to invalidate your new invention because everything you have in your new invention could be found in your prior act. So you want to make sure that your prior act does not invalidate your new invention, and as such, there has to be something new, an essential element in your invention, because sometimes what you are doing is just an upgrade of what has been on ground before, and as such, you just need to add a new essential element to what is already existing to get your own invention. So yes, prior act is very important. Also, you want to look at, then when you're looking at novelty, with respect to novelty, you can only invalidate an invention with a single prior act. So I can't pick prior act A and prior act B to join them together to invalidate the novelty of an invention. You can't do that. However, you can pick prior act A, prior act B, prior act C to invalidate the inventiveness of the invention. I don't know if you understand what I'm trying to say. So what I'm trying to say is, when it comes to novelty, it is just one prior act that you can use to invalidate novelty in an invention. But when it comes to inventiveness, you can pick 3 prior acts to invalidate inventiveness. Because let's say, for example, if there's an invention that talks about how to package maybe biscuits, that's the inventiveness. There's another invention that talks about you putting maybe something in the middle of the biscuits to separate it. And a third invention talks about something else that go in the same line. Then your own invention is a packaging material, and your own invention has an aspect of prior act A, prior act B, and prior act C. The parent examiner can break those 3 prior acts together to invalidate your invention, because when you look at A, B, and C, when you put them together, you're going to understand what this new invention is doing. So yes, 3 prior acts or more than 3 prior acts or more than 2 prior acts can invalidate the inventiveness of an invention, but it won't invalidate the novelty, because you just need 1 prior act to invalidate novelty as regards to claim drafting. Then what other aspects? Yeah, I think that's it for now. Thank you.
Thank you very much, Ma. I really appreciate the feedback. I believe, in fact, I've learned something very important, that the invention should be new such that it does not negate the prior art. That's a very important lesson to learn from here. Thank you very much, Ma. Before we proceed, about to proceed, I think we should have our question time now. Mentees, please, can you on your videos for us to have a short screenshot of ourselves? Don't worry, don't have to be in a very fine background. I'm also emotional. So mentees, please, put on your video, let us have a quick short screenshot before we go back to. Okay. Do all that victory is we are waiting for you. Just a quick one. Um, okay, I believe these are just the people that are really following us. So I will. Okay, you can on our video now. Also, for any question from the from the mentees for Shukuro, Mr. Vakesh is no more online. Any question from the mentees before we conclude? Mentees, Mrs. Shukuro has told us a lot of things. If you have any question, either from Mr. Vakesh, is a important stance. We will be. Okay. Please, any question?
Sir, I don't know if Mrs. Shukrat has answered our first question, because based on our slide, our first question was that what strategies can be employed to anticipate and mitigate potential challenges such as prior art and competitors' claim. I don't know if she has answered that particular question.
Can you come again? What's the question?
The question is what strategies can be employed to anticipate and mitigate potential challenges such as prior art or competitors' claims?
Okay. So are you talking from I want to understand the perspective you're coming from. When you say to anticipate, strategies to anticipate, meaning that you want to when you anticipate something, it means you're trying to invalidate it. The prior act is going to invalidate it. So I'm talking from an infringement aspect, like from a competitor aspect or an inventor aspect. Because if you want to anticipate, is majorly a competitor who is trying to invalidate somebody's patent.
Well, what are basically we are trying to say is that there are some certain things that an inventor would want to put in mind. Like for example, if you want to create a particular invention, maybe this particular a previous invention has similar attributes to what you're about to
Okay.
to make. So what are the ways that you can that you can create your own unique one that so that it won't infringe on the previous or prior art of that particular invention itself?
Well, the first thing you want to do is always carry out a search. Like you can't go wrong with a search, because when you carry out a search, you are able to understand what has been on ground before, what prior acts has been on ground, what exactly it is can you do to improve the prior act. Because when you don't do a search, then you're gonna have issues with someone invalidating or a prior act anticipating your invention. So the first thing is you want to carry out a search. And in carrying out a search, you want to understand the strategies in carrying out a search. You want to brainstorm the keywords. You want to look at the classes. You want to look at the classifications. You want to look at the technology for that search you are doing. Then also, if it's a prior act search, you want to focus on what has been on ground before. So the first thing first is search. By the time you carry out a search, I think someone's mic is on. Dennis, I think it's your mic. So when you carry out the search, you are able to see what has been in existence. Then you're able to compare it with what you are doing. So when you compare it, you see the gap and what exactly it is you can improve. So you go back, sit down, and re-strategize. You re-strategize and see how you can build your own invention around that prior act, such that the prior act will not be able to invalidate your invention. The next thing you want to look at is your claim. The claim you are drafting, are you sure what is in your claim is in the body of your work? Because you can't claim what is not in your application. So it always has to be in your application. And you want to make sure that it is as broad as possible. Not too broad, not too narrow. But you are trying to make it so that somebody else will not come and just infringe on your rights simply because you didn't claim it. Say sometimes if you're talking about maybe color, you really don't want to claim this is color red when you know that it could be color green or color yellow. So you want to be very intentional about drafting your claim. Also, another thing is the language of your claim. The language says a lot. Say you are using comprising or you are using consisting of. The languages also matters, depending on the jurisdiction. Then the other thing you want to look at is who exactly are your competitors, so that when you're drafting your claim, you know if you are drafting a single claim or you are drafting a multiple dependent claim. Are you drafting a product by process, or just a product claim, or just a process claim? So that when you are drafting that claim, you are able to look at who are the likely infringers that are going to probably infringe on my patent, or who are the likely people that are going to license this patent. So you're able to draft in such a way that it's going to benefit them at the end of the day, and probably you can have a license agreement with them when your invention is out. So these are some of the things you want to put in place as an inventor to avoid those pitfalls.
Okay, all right, man. Thank you very much, man.
You're welcome.
Thank you very much, now. I don't know if there's any further question. If you have a question that share to stop, send it in the chat. Can raise up your hand before we conclude. Okay. Any question? Okay, thank you very much, man.
I think we
Shukran.
have Ifunaya. Ifunaya says she has a
Okay,
question.
okay. If you please go ahead.
Okay, sorry, my background is very noisy. I was trying to type the question instead. Okay, my question, I'm sorry to take you aback, but I need clarification. I've not understood the difference between dependent claim and independent claim. I know
Can
it's
you
been
speak
said.
up a bit clearly? I really can't hear you. There's background
You
noise.
said, sorry to take you back, but
Okay.
I've not understood the difference between dependent claim and
Okay.
independent claim. I know it's been spoken, but I missed it, so I didn't get that point of the lesson.
Okay.
Thank you.
So when you talk about independent claim is the first claim. The very first claim you will see in any patent application is the independent claim. And the independent claim must be as broad as possible. So let's say the invention is for a pen. The claim could read a writing material. Like I said, take note of the article. The first claim should have an article A, not D. A writing material comprising maybe an ink, a pin, a this, a that, such that this does that. You make it very broad. You don't make it narrow. You won't come and say that the writing material is pink or is black, or you put it at angle 90 degrees. So the first independent claim is as broad as possible, such that each element you kind of link them together, so the person that is on reading the independent claim have an understanding at least of what exactly you are doing. But when it now comes to the dependent claim, you can now say the writing material in claim 1, wherein the ball is maybe gotten from aluminium oxide or this and that. The ball in claim 1, wherein the number of leg or the number of this is 3 or is 4. So in your dependent claim, you start breaking everything down one after the other. Your dependent claim gets narrow, and narrow. But your independent claim is as broad as possible, so that you try to pick everything in all the essential elements is in that independence claim. But for a dependent claim, your dependent claim will always depend on your independence claim. Now, in a case whereby you didn't mention a future in your independent claim, it will make sense that you now mention it in your dependent claim. It's like you're just bringing that future from nowhere. Say, for example, we're talking about pen, and your independence claim 3 is saying the writing material in claim 1, wherein the pen has 4 legs, and you're like, 4 legs, pen, where is that coming from? Okay, so you want to make sure that your claim is not undulating, it's going smoothly. Anything you've put in your dependent claim, in your independent claim, you now start analyzing them one after the other in your dependent claim. So in a case whereby you didn't mention it in your independent claim, then the claim that follow might say the claim in the material for writing, or the writing material in claim 1, further comprising means this claim or this particular thing I want to add was not mentioned in the independent claim. So I'm trying to mention it here so that I can talk about it later in my dependent claim. I don't know if you understand it now.
Very well, ma.
Okay, you're welcome. So if you have any other questions.
Okay. Sorry, can everyone hear me?
Yes, please.
Oh, okay. So, in the absence of any question, we would like to say a big thank you to Ms. Shukurat. Okay. Oluwadamilola, do you have a question? Okay. So, in the absence of any question, In the absence of any question, we'll be drawing a curtain on today's class. I want to say a big thank you to our mentors for sharing with us their insights into today's topic, patent claims and drafting. Right. It has been very insightful. They have shared quite a lot. Thank you to Ms. Amosa for helping us answer our questions and give feedback to our presentation. So please, I would like to kindly encourage mentees to share on their different social media platforms what they have learned today. Please kindly learn to or kindly tag our mentors so that people can get more. They can get more visibility to see that okay, they are contributing to this team and to what Gypsy is doing. Right. So please make sure to always tag our mentors. I want to say a big thank you to Mr. Nifemi, that is our moderator, for taking on and moderating today's session. Thank you so much. And with that, we've come to the end of today's session. Please do not forget to fill in the attendance form. Right, the presentation from Mr. Rakesh has been posted in your group alongside the picture for today. So kindly do well to, you can go through it, you can go through them, you can go through it and see anything that you might have missed during the session. You can also follow this session, the rewatch of this session. You can also rewatch this session on YouTube, right? It's being streamed live. Thank you once again, everyone, and please enjoy the rest of your evening.